Good afternoon, Anton Kaminsky for Kaminsky Law. Today we're going to start a new series called Legalese. What does legalese mean? Legalese is a term used by lawyers to describe legal terms. Ironically, it's called legalese, but the terms are very difficult and most people have absolutely no idea what they mean. So, our segment called Legalese is going to try to take those terms and put them in layman's terms, explain them to the everyday listener or viewer so that they can understand what they mean and what they mean to them, which is usually the most important part. Our last legal bit talked about contracts and why you wanted something in writing. It's only natural that our first Legalese segment would continue on those legal bits and talk more about contracts and try to explain why it is that lawyers, or I, will tell you all the time that you should probably have your agreements in writing. What is an agreement? It is a document that is going to contain the material terms of the parties' understanding amongst themselves. Material terms are terms of an agreement that go to the essence of the bargain. These all sound like legalese, right? Every single word that I just said pretty much sounds like a lawyer made up term. So let's break it down. A material term is a term that is important to the deal. What is a term that's important to the deal? Identification of the parties. Who is involved in the deal? The item, property, or service being exchanged. What am I providing to you? Or what are you providing to me? The terms of payment for that item. How much are we paying? What are you getting in return for this item? Time, place of performance. When are you going to do this? Where are you going to do this? How are you going to do this? And what is the scope of this? Now, that is a general view of the material terms. Very often, material terms of a deal will be very specific to the deal itself. Some terms that are important in one deal might not be so important in a different deal. The immaterial terms are sometimes also called subordinate terms. These are terms that are not essential. They're not as important. Now, they could still be important. Where are we suing if we have a dispute? Are we going to go to mediation, arbitration, or litigation if we have a dispute? These are certainly important terms, but they don't have any bearing on who does what, when, and how much they're getting paid for it. What happens if there's nothing in writing? Well, it is your burden to establish that there is an agreement. Here are some examples of things to help establish that you have an agreement. The conduct of the parties. What did you do? What did they do? When did you do it? When did they do it? Did they do it in response to a payment that you sent? Is there any sort of evidence that shows what they did? Let's talk about a specific contract so that everybody can get an idea of what you want in writing and why you want in writing. Let's say you want to build a pool and a deck in your backyard. Let's talk about the things that should go into that contract. Number one, how much are you going to pay for the entire project? Number two, what is the scope of the project? Are they just building the pool? Are they building the pool and the deck? Number three, what types of materials are they going to use? Are you providing the materials or are they providing the materials? Is the cost of the materials included in the price? Number four, how long do they have to complete the project? Number five, what happens with change orders? Let's say midway through the project you change your mind about something. Let's say you want an addition. Let's say they said you wanted an addition. How does that get achieved? Now, if something goes wrong, you can point to a contract and say, well, wait a second. You told me you'd finish by June 1st. It's now August. I think that there should be some set-off because of that. Or you told me it was going to cost $150,000, and now we're at $170,000 without any change orders. Why am I paying an extra $20,000? Can you see how it would be very difficult to argue these things if there's nothing in writing? One of the questions that I hear most often is, I don't have an agreement. What can we do? Well, let me tell you, this is why there's lawyers. Without you guys and not documenting your agreement in writing, we would have no jobs. Don't hesitate to reach out. Call us at Kaminsky Law. Consultations are always free.